Welcome to Lecture 9 in our series on medical law and professional ethics. This lecture is on the patient-professional relationship, and we will be describing informed consent when it's needed and how it can be given. We'll describe the confidentiality between a provider and patient. We'll talk about why it's important and when you can break confidentiality. We'll articulate the role of medical professionals in terms of patient advocacy. Explain legal and ethical challenges that can arise from refusal for patient treatment, provide the legal definition of abandonment and legal reasons the patient-provider relationship can end, and overall we'll just be talking about some of the more nuanced topics in consent. So the patient-professional relationship, it's unique, complex, it's always changing, and I do want to critique the book's opening paragraph a little bit. It seems somewhat adversarial, where it talks about patients coming to their appointments armed with information. And rather, I'd like to think of it as equipped with information, that now the patients are oftentimes a more important member of the team. They have a larger say, and they also have a larger understanding of what's going on overall, and that benefits everybody. Overall, it makes our job as providers much easier to care for people who want our help than people who don't care. But achieving those better outcomes does require mutual respect and clear articulation of expectations by both parties. So, what is informed consent? This is the agreement that you have between your provider saying, or the patient between the provider saying they understand what the provider is going to do and they want the provider to perform that procedure. And consent can either be implied or express. Implied consent is something where the patient does something to indicate their consent. For example, if they're calling to schedule an appointment, that's giving implied consent for that appointment. Whereas there's express consent, which is the direct verbal or written authorization of care. And that's something where if you sign a form, you're giving express consent. A lot of the times for more high-risk procedures, they'll want express consent, whereas routine procedures, diagnostics, they might just have implied consent. You're already there. That's showing that you want the diagnostic. It's not a risky thing, so let's just do it. So if consent is not given, then the treatment is considered against the patient's will, even if the healthcare practitioner did not intend any harm. And if you remember from Lecture 5, anytime you touch a patient without their consent, it's considered battery. And when related to medical care, it's considered medical battery, and it's defined as the intentional violation of their right to direct their own treatment. So in order to obtain proper informed consent, certain crucial pieces of information need to be given to the patient, like the risks and consequences. These pieces need to be present for the consent to be considered informed. Now, if you were to encounter somebody that's unconscious because of an accident or another medical emergency, that's a very common situation where implied consent comes into play. And in that situation, the average reasonable individual would be considered to want care to prevent some sort of life-ending injury. So based on the presumption that the person is just a regular, reasonable person, you would have their implied consent to try to save their life from whatever issue just happened. These laws are called Good Samaritan laws. All right, so in order to give informed consent, a patient needs to have decision-making capacity. That means they need to be able to make a specific decision at a point in time. They have to comprehend the information about their medical condition. They have to reason and consider various options and make a choice consistent with their own values and beliefs and communicate that choice consistently over time. A lot of the times nurses' role comes into that part about making sure the choice is consistent with their values. We're not the one that's explaining everything to them, but we are making sure that it seems like they're making a choice that reflects their own personal values. So a patient's ability to make sound decisions might be impaired by their illness or their treatment. For example, if someone has Alzheimer's disease, their ability to make decisions about their care is going to rapidly decrease. And sometimes that creates tension between professionals as they attempt to maintain patient autonomy and balance the concept of beneficence and maintaining the best course of action for the patient. A lot of the times this can even create conflict within families about what is best to do for the patient. Ultimately, the one who decides a patient's decision-making capacity is their attending provider. And they will evaluate whether the patient understands information given to them, comprehends the consequences of their decisions, and are using logic to make their decisions. Religious beliefs are universally accepted by healthcare professionals as valid reasons for refusing medical treatment. If you are not able to provide consent for yourself, or a patient isn't able for themselves, they will have a surrogate decision maker, and that's somebody who's been entrusted by the once competent patient to make decisions on their behalf when they are not able to make those decisions. The moral principles behind these surrogate decision makers are preserving patient autonomy and beneficence. And people can appoint multiple surrogate decision makers. These decision makers are generally appointed through the durable power of attorney documents that we discussed, as well as the different lines of succession for decision making based on the state that you're in and other factors as well. Another important concept is called the extension doctrine, and that's the idea that if a patient provides consent for a procedure, anything that's discovered during that procedure that is immediate, important, possibly life-threatening, there is an extension of consent for any procedure related to that specific issue. So the original informed consent is extended to cover the new circumstance. So confidentiality is incredibly important in medical relationships, so important that we have many laws that regard just privacy and confidentiality specifically. Healthcare providers are almost never allowed to share patient information. There are only very specific exceptions. I believe HIPAA names 12, and some of them are broad, so it is really just 12. Some of them are like court orders. They're all national security exceptions. They're things that affect other people, not just the patient. But it's always important to be mindful of where you're talking about patient information. There's a classic example of providers standing in an elevator talking together about a patient, and a patient's family member is in the elevator with them and hears everything. They might say something about the patient that the family member didn't know. They might say something inappropriate. They might not. It's just uncomfortable and inappropriate for them to be talking about their patient in an elevator like that. So don't be that provider. So like I said, there are situations where patient records can be disclosed. And in these situations, you should inform the patient about the disclosure, even though their consent is not required. So court orders are probably the most common, and that's when patient records are open to third parties because of court processes. You know, let's say somebody gets in a car crash because they were drinking and driving. They might subpoena medical records to see what their blood alcohol level was. Then there's also different statutory requirements. So every state has different conditions that need to be reported to legal authorities. A lot of the times these are things like gunshot injuries, child abuse, certain communicable diseases. And these duty to report does not always apply to physicians alone. This can extend to nurses and other allied health professionals. Just like I said, serious communicable diseases, things like HIV, measles, anything that's potentially infectious oftentimes needs to be reported to the local health board. And those conditions are specifically referred to as notifiable conditions or notifiable diseases. For threats of self-harm, the provider has a duty to take actions to reasonably prevent any specific threats from occurring. And so you would have to breach confidentiality in order to report something that would prevent that. When a third party is in danger, so if a patient threatens to hurt someone else, you have a duty to make sure that that person is warned. And same thing with illnesses as well. That's kind of the same concept, that you don't have the right to go around infecting people. So, as much as it might seem overdramatic, I would say to treat every decision you make in healthcare like you're making it in front of a court and you're going to have to answer for your actions in court, because that might just be the case someday. Confidentiality for minors is a little bit different than confidentiality for adults. In most cases, the parents should be involved in decision making and treatment, although there are some specific exceptions, often dealing with family planning and adolescence. So if a young woman gets pregnant, that might be something that she doesn't want to disclose to her family. And in those situations, a lot of the times there are statutes that allow for the patient to have a certain level of autonomy and privacy. For example, in Illinois, children who are 12 and older can receive treatment for sexually transmitted diseases, drug use, and alcohol use without parental notification or consent. Other situations, there's a limited amount of time that a professional can act. So I think for a therapist, they have something like 30 days or 90 days or a certain number of treatment sessions. Yeah, I'm not sure the exact amount of time, but there's a certain amount of time that providers are allowed to work with minors before they disclose to their parents. All right, so next, what are patient advocates? Those are people who serve as a liaison between the patient and anyone involved in their health care. And first and foremost, you should be a patient advocate. Everyone who works in healthcare ideally should be a patient advocate to some degree. It's about keeping in mind who you work for. That we work for the patients. We don't work for our employers. We might work for our employers in some senses, but ultimately we're here to work for the patient. So taking that attitude, you are trying to provide the most benefit for the patient. You're the one that's looking out for their goals, their needs, the risks that they're experiencing. So patient advocacy can be something that you're doing at all different levels. Everyone does consistent with their own levels of expertise. So a nurse, for example, can alert a physician about an order for a medication that a patient is allergic to. A nurse's aide can report unsanitary or unhealthy conditions from maybe the patient was left in poor condition from the previous shift. All sorts of different things. Everyone is encouraged to advocate for patients at every level in the health system. And finally, we have patient abandonment. Refusal of medical treatment and patient abandonment. So when can patients refuse medical treatment? Anytime they want. And then when can they change their mind? Also, anytime they want. But when a patient refuses treatment, providing care anyway can result in lawsuits for battery, negligence, and lack of informed consent. It violates patient autonomy to provide care without their consent. And religion is something that is pretty much universally considered an acceptable reason for refusing medical treatment. All right, and what about you? Can you refuse to give care? The answer is generally no. That's considered medical abandonment, and that's when you terminate the patient-professional relationship in a way that denies the patient medically necessary care. So if you don't give the patient reasonable access to follow-up care, then you would be considered abandoning the patient. You need to give them reasonable notice or provide a competent replacement. And this gets a little bit sticky in situations with staffing with nurses. So let's say you just finished a 12-hour shift and you have another 12-hour shift in 12 hours, or more like 11 and a half hours. And you've got a long commute home and all you want to do is go home, eat, sleep, and come back. But then your boss comes and tells you that your replacement didn't come, so you need to stay and you need to fill in. Otherwise, you will be abandoning your patients. And that's a wonderful, much longer discussion about who is actually doing the abandoning there and why you could leave and they couldn't actually come after you for abandonment, that they would technically be the one abandoning the patient. But that's neither here nor there. We're not going to go into the weeds with that. If anybody wants to, come talk to me during office hours. We can make that a discussion post if you're interested. But anyway, back to it. What is abandonment? It doesn't occur if the patient decides to terminate the relationship. It doesn't occur if it's mutually agreed upon, only if you choose to leave the patient and you don't give them the opportunity to continue to receive quality care. It can be alleged that you abandon patients if you, for example, quit without letting your employer know, so you just don't show up to your next shift. That's something that, on the continuum of patient abandonment for nurses, that's pretty bad. Don't do that. And then for abandonment, there are two different types. There's intentional abandonment and inadvertent abandonment. It's pretty self-explanatory. As you can imagine, intentional abandonment is abandonment you intend. It's abandonment that was meant to happen, and generally speaking, in court, that's looked upon more negatively than inadvertent abandonment, which might happen because of a mistake on a schedule or just a general miscommunication. So that is it for Chapter 9, the patient-provider relationship, and I will see you in the next lecture. Thank you so much for watching.